Welcome everyone to Doughty Street Chambers Court of Protection Case Law Update webinar. With Sophie Miles and Mary Rachel McCabe, I, Gemma Daly, will be talking about the case law updates in the Court of Protection since around June 2020 until now. So we will be going through a number of different cases, recent cases on relevant current issues, as well as some cases that will have been already provided in the legal action group update that we drafted together and should have been shared with you already before today's webinar. So we will be covering, first of all, I will be speaking about COVID-19 vaccination cases, very topical, and 2 obstetric care cases. Mary Rachel will then be talking about sexual relations post-JB and Court of Protection. And Sophie will be looking at damages in the Court of Protection, leaving the jurisdiction, and vexatious correspondence. And we'll have some time at the end for Q&A. Next slide, please. So as I've said, LAG have kindly let us share with you the February 2021 update that we've already prepared, and there's been more cases, as is always the way, already since then. So we'll be covering particularly the new cases and a couple of key ones from the LAG update. Starting then with COVID-19 vaccinations and the first COVID case that we had, the COVID vaccine case that we had of Re-E. And this was before Mr. Justice Hayden. And as with all of these cases, I should say that it is, of course, fact specific, but they help to set out the process of how the court is addressing COVID-19 vaccinations. And of course, as we know under the MCA, the approach is always to assess capacity first, and then if a person lacks capacity to make that specific decision, to determine what is in the individual's best interests in relation to that issue. So in this case, E was an 80-year-old woman with dementia and schizophrenia living in a care home. The local authority had informed her accredited legal representative that she was going to be offered the vaccination. And there were some existing proceedings already underway in the court relating to her residence and care. Her son objected to her being vaccinated, and so in fact, when she was offered the vaccination in the care home, she was not vaccinated. And what happened was there was an application to the court by her representatives. So as it was already in the court, there was an ALR involved, it was already in the court jurisdiction, and it was her representatives who made the application. The first point in relation to capacity is that the court had reasonably limited capacity evidence. There was an attendance note of a conversation between P, her ALR, and her general practitioner. And Mr. Justice Hayden described this as an informal assessment. It was a video call, but nevertheless sufficiently rigorous to comply with Section 2 and 3 of the MCA. And the declaration was made ultimately that she lacked capacity to decide whether to receive the COVID-19 vaccine. And Mr. Justice Hayden described Mrs. E as being unable to understand information concerning the existence of the virus and the potential danger it poses to her health. He said, "I'm also satisfied that she is unable to weigh information relating to any advantages or disadvantages of receiving the vaccine. It is also clear that she cannot retain information long enough to use it to make a decision." He said this is because of her dementia. So that being a consideration of the relevant information in relation to COVID-19 vaccination and the causative nexus in this case being her dementia. Next slide, please. Turning to best interests, and specifically this individual's best interest, because of course it is always specific to that person and the facts of the case. This P had chosen to be vaccinated in relation to other issues such as flu and swine flu when she'd had capacity, and that was a relevant factor to take into account when determining where her best interest lay in relation to the COVID-19 vaccine. While she lacked capacity, she had articulated trust in the professionals caring for her, saying on a number of occasions as part of the capacity assessment that she wanted whatever is best for me. Now, her son had been the one who'd objected to her being vaccinated. He was sceptical about the vaccine, but Mr. Justice Hayden described his views as being a facet of his own temperament and personality and not reflecting his mother, P's, more placid and sociable character. And of course, it is Mrs. E's approach to life, he said, that I'm considering here and not her son's. And Mr. Justice Hayden took judicial note of the particularly high risk of serious illness and death to elderly such as Ms. E in care homes from COVID-19. And essentially, the paragraph 17 quote we have here summarises it, that in stark terms, the balance that Mrs. E, aged 80, must confront was between a real risk to her life and the unidentified possibility of an adverse reaction to the virus, that being the concern of her son. The risk matrix is not, he said, to my mind, a delicately balanced one. Next slide, please. And the list of the characteristics that Mr. Justice Hayden set out and are really useful to consider for anyone with similar characteristics, I'd say, were considered to be compounding her vulnerability to become seriously ill. And factors that we're all familiar with now, her age, being in her 80s, living in a care home. The care home had recent cases of COVID-19. She was diagnosed with type 2 diabetes. And due to the fact that she was unable to understand the nature of transmission of the virus and its challenges, she was unable as well to comply with social distancing restrictions. And it was noted that the vaccination reduces the risk of death dramatically, of course, and there was no hesitation in the conclusion that it was in her best interests to receive the vaccine. So quite a firm first judgment that we had, stating very clearly that it was in this person's best interest to have the vaccination. Next slide, please. The next case we had is Re V, and this was an application opposed by P's daughter at SD. And P's daughter had actually made the application for a declaration that it would not be lawful to administer the vaccination to her mother, as she considered it contrary to her best interests. Interestingly, the daughter, SD, who lived in New York, was appointed as litigation friend for her mother. That there's no more about that in the judgment, so we don't know the reasoning around that, but she was appointed as litigation friend for her. The local authority opposed the application and considered it to be in her best interest to have the vaccination. Again, there's very limited information in the judgment as to why it was the local authority and why there wasn't a health body, for example, involved, but that was what happened and what we know from the case. The court had evidence remotely, as it's now familiar with, from the daughter, the social worker, and P's carer, so the person who'd been providing her daily care in the care home. And this was a woman diagnosed with Korsakoff syndrome and living in a care home, as I said. She was described by her daughter as being deferential to those in authority, particularly the medical professional. Conversely, Mr. Justice Hayden described the daughter as querying and mistrusting advice. And the circumstances that had led to the proceedings were that the daughter had emailed the care home saying she didn't think her mother should receive the vaccine, telling them not to let her receive it. And on the day of the vaccination, P, in fact, followed the other residents into the room to have the vaccination, but had to be told that she wasn't going to receive it. And what we're told from the judgment is that she stood around for a little while, sort of waiting for it, and then left, and it seems later forgot about it. She had had annual flu vaccines in the care home over a number of years, and the GP's advice was unambiguously that it was in her best interest to have the vaccination. So those were the circumstances around the application. Next slide. In relation to capacity, limited information in the judgment because it was quite clear, we're told, that there was no question that she did not have the capacity any longer to evaluate the question of receiving the vaccine for herself. In terms of best interests, Mr. Justice Hayden referred back to the Re-E risk matrix, and he said it applied equally to circumstances here. So the characteristics that made her particularly vulnerable to severe disease or death if she contracted the virus were that she was 70 years old, significant excess weight, had dementia, and lived in a care home. And it was impossible, as with E, to follow social distancing and preventative hygiene. And interestingly as well, the last point here, there was note given to the fact that because all the other staff and residents had been vaccinated, there was going to be an opening up essentially over time of the care home, which would expose P to greater contact with the outside world, increasing the risk to her. So whilst it may be thought that other people getting vaccinated could reduce the risk to her, in fact, because of the world opening up, we hope, gradually, and the care home opening up as more people are vaccinated, that would expose someone who's not vaccinated to more risk. Next slide, thank you. The submission from the daughter was essentially that whilst P had taken flu vaccine, accepted the flu vaccine in the past, she was simply following the herd. She said that didn't really reflect her wishes and feelings, but was more part of her disease and her dementia. And the court didn't accept that. And the court took the carers' views into account, as well as the daughters, and as well as the GPs. And whilst the daughter was enthusiastic about other solutions, Mr. Justice Hayden warned about well-meaning and concerned family members' views, of course, being taken into account, but not being permitted to prevail nor allowed to create avoidable delay. And to do so would be to expose the vulnerable to the levels of risk he'd identified in the face of what remains an insidious and highly dangerous pandemic virus, as we're all aware. And ultimately, the risk to her life, if she were not to have the vaccine, was considered to be unacceptably high, and therefore it was in her best interests to receive it. The court was critical of the delay that had been caused in bringing the actual proceedings to court. So the care home, well, the daughter had notified the care home by email that she didn't want her mother being vaccinated, and the care home notified the local authority a month later. And it took nearly a month for an application to come before the court, that application being by the daughter herself in the end. And Mr. Justice Hayden warned that when an issue arises as to whether a care home resident should receive the vaccination, the matter should be brought before the court expeditiously if it is not capable of speedy resolution by agreement. And this is not only a question of risk assessment, it is an obligation to protect P's autonomy. So a reminder there of the importance of promptly bringing proceedings, including in relation to COVID-19 vaccinations, if there's a dispute. Next slide. This week, I believe it was a judgment published in the case of CR, and this was a judgment of His Honour Judge Butler. And in this case, again, there wasn't an issue in relation to capacity. It was accepted by all that CR lacked capacity to make a decision about COVID-19 vaccination. Slightly different circumstances here. We had a much younger P, 31-year-old with severe learning disability, autism and epilepsy, also living in a care home. And it wasn't possible in these circumstances to determine his wishes. All professionals involved considered it to be in his best interest to have the vaccination, but his father opposed it. It seems from the judgment that he didn't oppose it in principle, but that he didn't think he should have it at that time. And that, in fact, is quite similar, it seems, to the other objections in the earlier two cases. In this case, the objections of P's father were described as being linked to the discredited theories of Dr. Andrew Wakefield, those being in relation to the purported link between autism and the MMR vaccine, which of course has been discredited. And CR had in fact not had any vaccinations since he'd had the MMR at birth as a consequence of the parents' views. Next slide. Sorry, I was thrown a bit by the weird formatting there. The court considered the relevant circumstances for this individual, but also generally the circumstances of the COVID-19 and the infection and death rates across the UK, as well as vaccination. And then in terms of specific circumstances for this P, he was also in a care home. He was clinically vulnerable, overweight, unable to socially distance and follow the hygiene measures. So similar factors to what were considered in relation to V and E. And he didn't have any anxiety, it seemed, about medical intervention involving something sharp. He'd had some procedure in January 2021, and there was a potential consequence for health, of course, if he contracted COVID-19. And the court considered both the SD case, which is Re-V, and Re-E. And obviously here there's a difference of the age, so not the same level of risk, but nevertheless risks specific to this individual, and the consequences of infection would still be high. So it engaged with specific reference to Article 2 ECHR rights. And the family's views were, of course, taken into account as was required under Section 4 of the MCA, and described as no doubt being founded on the love that they had for P, but the court commented on the objections being linked to discredited theories that I've mentioned. And ultimately, the finding was that it was in P's best interest to have the vaccination, but notably did not authorise physical intervention in order to do so. So it didn't seem that P in this case would object to something sharp, but if there was going to be a requirement for any physical intervention, that was not authorised by the court. The principles that I think we can take from these are not really groundbreaking. They essentially follow the MCA in terms of capacity assessment for a specific decision, and then best interest decision making if someone lacks the relevant capacity, following the Section 4 checklist. I've included a quote here from Re V of Mr. Justice Hayden, and the emphasis that the need for respect for and promotion of PEE's autonomy and an objective evaluation of PEE's best interests will most effectively inform the ultimate decision, and a reminder that it's PEE's voice that requires to be heard. It should never be conflated or confused with the voices of others, including family members, however unimpeachable their motivations or however eloquently their own objections are advanced. So the reminder of the focus on P. And then of course we've got that reminder to not delay proceedings if resolution cannot be reached speedily, of course with the very serious potential consequences of serious ill health or even death related to the vaccine, to the virus. Next slide. There is NHS guidance, I'm going to whiz through this one, on vaccination, essentially for vaccination centres. It really just says that best interest decisions must be made on an individual basis, and it suggests that patients should be provided with written information about the vaccination. And it provides some guidance for vaccination centres on how best interest decisions might need to be made, but it's nothing different than a sort of summary, if I can put it that way, of following the MCA. It doesn't mention, interestingly, going to the Court of Protection, which of course should be done if there's any disagreement with a deputy or attorney's decisions in PEE's best interests, or if there's a disagreement as to their best interests. Next slide. The Office of the Public Guardian has a blog online about those being vaccinated and what it suggests they should understand, retain and communicate, presumably use and weigh as well. Those being the possible benefits in the simplest of terms, the likely side effects and any individual risks should of course be understood, and what could happen if they don't consent. That's just the OPG suggestion, and I would suggest that we look at the cases instead, and the way in which Mr. Justice Hayden, particularly in Re E, talked about the information that a person needs to understand, retain, use and weigh. Next slide. The OPG also has a link on that website as to how to find out if someone has an attorney or deputy, so that NHS and social care staff can check if there is someone who can make the decision in relation to COVID-19 vaccinations, because of course next of kin is not the same and shouldn't be making decisions about COVID-19 vaccinations. Next slide. Moving on to obstetric care, we've got two recent cases, one in relation to a planned C-section and the second in relation to an emergency C-section or potential C-section. In this case of Miss A before Mr. Justice Cohen, it was a woman in her 30s who was 38 weeks pregnant and with paranoid schizophrenia. The two trusts who made the application were respectively responsible for her obstetric care and mental health, and the OS was litigation friend for Miss A. She had had various hospital admissions and a history of referrals to mental health services, and she had conceived the child following ending her medication or stopping her medication in September 2019. Sadly, in 2020, concerns were raised about her mental health and her functioning at that time. And by early 2021, her consultant obstetrician had formed the view that she lacked capacity regarding her mental health care and treatment, as she was demonstrating no insight into her previous illness. And she was hoping to have what was described as a normal vaginal birth at home. Next slide. In January 2021, so earlier this year, there were a few incidents that caused concern to professionals and that ultimately led to her being detained, firstly under Section 2 of the Mental Health Act and subsequently under Section 3 of the Mental Health Act. And she was assessed by two doctors as lacking capacity in relation to both mental health and obstetric care due to a severe relapse. She didn't want her medication and she wanted to leave hospital to return home to have the baby at home. But the fetus was in the breech position, and so a procedure was proposed to try to address that prior to the birth. And she was described as not being able to weigh up the small chance of complications of that procedure and the benefits if successful when compared with the potential risks attached to the breech birth. So she refused the procedure on the first occasion. On the second occasion, she declined the injection and the doctor attempted it without injection and it was unsuccessful. So the options before the court by this stage were either a vaginal breech birth with the risks that were involved and the risks involved in an emergency C-section, or a planned cesarean section. And it was noted that even if she'd taken her mental health medication, which she was refusing, it wouldn't make a difference by the proposed date, which was, I believe, a week later. Next slide. In relation to her capacity, the court determined that she was still unable to weigh the risks of what she wants, namely a vaginal birth at home. And there was no doubt that a birth at home would be very risky, and in any event, she would not be allowed to return home as she was detained. And her focus seemed to be on the discomfort that she thought she would feel. But in fact, the most important thing to her was described as being for her and her baby to be healthy, well and safe. And the court noted that there was no doubt that if she'd regained capacity, it would be her wish to have a safe delivery of her child. So at that time, she lacked capacity to make those decisions about her obstetric care and treatment. And ultimately, the risks of the planned C-section far outweighed the risks of not having it. And it was determined to be in her best interest to transfer to the maternity unit for an elective C-section, elected by the court. And her capacity would continue to be assessed thereafter. Next slide. There's an emergency case then next of GH before Mr. Justice MacDonald, an out-of-hours case which concluded at 11:45 at night, and the official solicitor in person was litigation friend 4P. And this was a 26-year-old woman who suffered from anxiety, depression, acute agoraphobia, and had gone into labour 72 hours earlier, but was suffering an obstructed labour. And she was refusing the urgent inpatient treatment and possible emergency C-section. Next slide. It had been an out-of-hours application, interestingly, because she'd been assessed as having capacity to make those decisions and had in fact agreed to hospital admission until late that afternoon. So until she'd been in labour for, at that point, I suppose, close to the 72 hours. And it was only at that point that her anxiety and agoraphobia were described as becoming the dominant feature in her decision-making, and then she then lacked capacity. But of course, the normal approach in such cases is to engage in early and thorough planning to avoid urgent applications. Next slide. The particular risks for her at home were related to the fact she hadn't had any scans because of her agoraphobia and a raised BMI. And the family essentially and her partner all supported her being admitted to hospital. Next slide. Sorry, I'm whizzing through these, I'm conscious of time. She was found to lack capacity to decide whether to agree to be admitted to hospital at the time of the hearing and to the possible emergency C-section because of her agoraphobia and anxiety. And ultimately, it was in her best interest to be conveyed from home to hospital by ambulance and for the treatment that the medical professionals considered to be in her best interest to be delivered. And this could include a deprivation of liberty, as was set out in her management plan. Just one more point on that last slide, that just to let you all know, as it says in the judgment, she did give birth to a healthy baby boy at home before they were able to execute the arrangements authorised by the court. So a good story and a good end to the story anyway for her. Thank you. Sorry for whizzing through the last ones. I will pass over now to Mary Rachel.
Thank you, Gemma. So I'm going to speak now, first of all, about the case of HD, which is a post-JB capacity to engage in sexual relations judgment. And full disclosure, I acted as junior counsel instructed by the official solicitor in this case, led by John McKendrick, QC. So this is a judgment of Mr. Justice Cobb. And HD is a young woman in her late 20s, very vulnerable young woman with a mild learning disability, epilepsy and diabetes. And until spring of 2019, she lived at home with her parents. But around March 2019, she started seeing a man who's known in the judgment as Y. And her family understandably didn't approve of Y because he was described as a very high-risk sex offender. They were in a sexual relationship. And indeed, HD made some allegations that he sexually assaulted and raped her. And so HD's family eventually said that she couldn't continue living at home while she remained in a relationship with Y, and she wanted to remain in a relationship with Y. So she was then placed by the local authority in a residential care home. And throughout the first 6 months of the proceedings, she remained in a relationship with this man, albeit they didn't see each other because of COVID restrictions, but also B, he was in and out of prison at the time for assaulting other women, not HD. But fortunately, she then ended this relationship in around May 2020 when he'd been recalled to prison. Next slide, please, Ray. So yeah, she eventually ended the relationship with Y, and by the time the hearing came around, she was in another relationship with a young man who's named as Z in the judgment, and he also has a learning disability. And just to have some awareness of HD's character, she dreads the notion of being single. That's recorded in the judgment. She becomes visibly distressed when it's raised with her as a possibility. She does have a history of making what appeared to be unfounded allegations of sexual assault against men, and she had also been known to share naked photographs of herself on the internet. But in terms of her relationship with Zed, again, they weren't actually able to see each other because of COVID restrictions, but they were in a very loving relationship. I just spoke on the phone every night, and HD wears a ring on her wedding finger, and she says it is her intention to marry him. Next slide, please, Ray. So the case started out as just a fairly straightforward Section 21A application before a Tier 1 judge. But it was clear that it raised wider Section 16 issues because her care plan included restrictions on contact, internet and social media, and of course, sexual relations. And the local authorities' capacity assessments at that time said she lacked capacity in all of those areas. And as proceedings developed and the expert evidence, which I'll come to, became quite complex, that's when we reached the stage of needing a Tier 3 judge and indeed leading counsel. But by the time of the hearing in January, the best interests issues were resolved in that the local authority had found a flat for HD, a supported living flat, and we were all agreed that she should move there. But the outstanding issue was capacity, and really only capacity to engage in sexual relations, because the evidence was quite clear that she lacked capacity in all of the other areas. Next slide, please, Ray. So as I say, the expert evidence in this case was really important, and it's interesting, and it's worth reading the judgment for that reason alone, really. It's quite a short judgment. So we had three reports from one expert in the case. So HD, she had received psychology support and education on intimate relationships as the proceedings went on. And in particular around power, risks, sexual health and lying. This was funded by the local authority, given the very high risks to HD based on her past behaviour. And so the first two reports from the independent expert, who was a psychologist, concluded that she lacked capacity in all of the areas under assessment, but that she had capacity to consent to sex. And that was applying the pre-JB test, which was in place at the time of those reports. And so the need for a third report arose out of JB because the relevant information had changed. Next slide, please, Ray. And just as a reminder that we've covered JB in our legal action update, which I think was emailed to you this morning, but just as a very brief recap, paragraph 100 of JB set out the relevant information for capacity to engage in sexual relations, and it said that it may include the list that's in front of you. And the line in bold is the additional piece of relevant information, of course, that JB added to the test, which is that the other person must have capacity to consent and does in fact consent. Next slide, please, Ray. So the court sets out or summarizes the expert evidence at paragraphs 24 to 26 of the short judgment. And the evidence basically said that HD was only just on the side of having capacity under the pre-JB test. And the expert said that HD's partner, Zed, who also has a learning disability, he thought that he might lack capacity to engage in sex. And that raised the question, do these two people both have capacity to consent to have sex with one another? And the expert, Dr. Carrot Baker, thought that this would involve undertaking capacity assessments both of and with both parties, because otherwise, next slide. Otherwise, he said, we're effectively asking both parties who are known to be intellectually impaired to be undertaking something like their own capacity assessments of one another, because what else could using or weighing the fact that the other person must have capacity actually equate to? Next slide. So the expert's written evidence was tricky in itself, and it seemed even actually more complex the more oral evidence that he gave, and his oral evidence certainly underlined the difficulty in assessing whether HD or someone like her does or doesn't have capacity in relation to sexual relations under the new test. And this quote from the expert's oral evidence is contained in the judgment, which is that the test makes more sense when one has capacity, but when two people might lack capacity, we get into the problem of circularity. We're then asking the question of both parties. Each party must make some appraisal of the other's capacity to consent. You can only solve the problem by engaging with both parties. So I think those comments are somewhat troubling because they raise the suggestion of a test where the characteristics of the proposed partner affect the outcome of the assessment of capacity. But next slide, please, Ray. In any event, the expert concluded in his oral evidence that he didn't think that HD would be able to achieve an understanding of the need to assess the capacity of her sexual partner's decision to engage in sexual relations. He said it was beyond her ability. And he also was pessimistic about whether a further package of education could help her to process that somewhat abstract requirement, which is essentially an assessment of capacity of any sexual partner. And he thought that at best she might be supported to understand that relating to a specific partner, but he did recognize that the test currently is not person specific. Next slide. So the court also heard some oral evidence from HD's safeguarding manager, and she was a bit more hopeful that HD could acquire capacity on that new piece of relevant information. She gave evidence that HD had worked really hard in the previous package of education in order to attain capacity, but sadly the goalposts for her had widened under the new JB test, and she just failed to cross that hurdle. But she thought she could possibly with education cross the hurdle, but she did again acknowledge that it would be a struggle given how abstract the concept is, if not done in a person-specific way. Next slide. So sadly, really, as the evidence came out, we were driven to accept that HD does lack capacity to engage in sexual relations under the current test. And so the court agreed at paragraph 27 of the judgment. And Mr. Justice Cobb did say in the judgment that he probably would have reached the opposite conclusion had the case been listed before him before JB. And he did also make a comment in open court that HD's case highlighted how complex the law in this area had become. And I think that's something we all agreed with in the courtroom. Ray, next slide, please. So we did give some thought to whether the relevant information could be tailored, because of course in JB at paragraph 100, the wording is that the information relevant to the decision may include the following, and then sets out the list. And JB did say that a question remained as to whether the relevant information must always include all of those matters which are listed at paragraph 100. And JB then goes on to reference cases where the relevant information was tailored. So, for example, in the recent Mr. Justice Hayden judgment in NB, he held that the relevant information should incorporate P circumstances. And in TZ, and the references there in the slide, Mr. Justice Baker tailored the relevant information so that a gay man didn't need to understand the risk of pregnancy. So the OS, as I say, gave careful thought to that, but in the end accepted that the circumstances didn't exist in this case for the court to tailor or disapply the application of any of the relevant re-JB information. So in my view, there are some obvious cases where there might be the potential to tailor the relevant information. and, a same-sex relationship, removing the risk of pregnancy from the relevant information seems an obvious one. I personally think it's difficult to envisage a case where this new piece of JB relevant information on the capacity of the partner to have consent, capacity of the partner to consent, I think it would be difficult to tailor that out of the relevant information for any proper reason, really. And so again, the court agreed that there was no proper basis for distinguishing HD's case from the ordinary run of cases, and therefore the information relevant to the decision should be those set out in Re JB. Next slide. Shall I go through this case, or shall I hand over to you, Sophie, maybe, and just leave the slides for people to read?
Mary Rachel, why not go through it, because I've got slightly fewer cases than you, and one of them is in the update anyway, whereas this is a new one. So if you don't mind, stick with it for a bit longer.
No,
Thanks.
I don't mind. I didn't want to steal your time, Sophie.
No, don't worry about that.
So this is a completely different case, and it's not in our lag update. A local authority and GP, and it's about capacity on care, support and education. And the reason I think it's interesting is because it considers the relevant information for 3 areas of capacity that haven't previously been the subject of judicial consideration. And I'll go as quickly as I can, but this is a judgment of His Honour Judge Christopher Dodd. GP was a 19-year-old man with diagnoses of autism, learning disability and anxiety. Previously at a special school, but he hadn't been at school since July 2018, and the local authority therefore had concerns about his lack of meaningful activity and community access. And the court was looking at whether he had capacity to make decisions to accept or refuse care, support and education. So the judgment's very clear, I think, and again, it's quite short and worth a read. It goes through each of the decisions in turn and sets out what the relevant information should be. The first decision is GP's capacity to refuse an assessment of his care and support needs pursuant to the Care Act 2014. And so the local authority and the OS were agreed on what the relevant information should be, or what the majority of the relevant information should be in that case. And that's what's set out on the slides there. So a local authority has a statutory duty to meet eligible needs. Assessor may speak to other adults or professionals involved in P's care, and the P may refuse to consent to that. And the local authority will assess how GP's well-being can be promoted and whether meeting these needs will help GP to achieve his desired outcome. So it reflects largely the wording of the Care Act there. So there was an additional piece of relevant information put forward by the OS in relation to this decision, and that was the importance of GP participating as fully as possible in decisions related to the assessment of his needs and how those needs can be met. And the court said that that was a value judgment rather than information relevant to the decision, and in any event too nebulous to amount to the reasonably foreseeable consequences of deciding one way or another. So that's why really it's an interesting decision to read, because it's a good reminder of what might be relevant information and what might be what the court said was a value judgment. Next slide, please. So the next decision that the court looked at in this case was to make care and support, and that's not new, of course. That's fairly well established, so that the court just reiterated the guidance in LBX and KL&M, which I've set out there on the slide. Again, the local authority had suggested some additional relevant information, quite a lot of additional relevant information, including why having a support worker is important to GP to access the community, and the importance of regular access to the community to build and maintain confidence. But again, the court said those factors are nebulous value judgments rather than relevant information. And the court reiterated that relevant information needs to be a salient feature of a decision about care and support. So it's a good reminder again of first principles, really, and how relevant information should be just that, the information that's relevant to the decision. It shouldn't go beyond that, because that raises the bar too high generally. Next slide, please. So the third decision to request an EHC needs assessment under the Children and Families Act. And that's, again, a new decision, a new area of capacity that hasn't been given judicial consideration, as far as I'm aware, before. And again, the local authority in the US agreed on the relevant information, and I've set it out there on the slide, just what an EHC plan is, that other people will be consulted, an enforceable right to the education in a plan, and that it's only available up to the age of 25. And again, the court rejected 2 more pieces of relevant information that the local authority had put forward on the basis that they added nothing concrete and they were too nebulous. And next slide, finally, the last decision that the court looked at was GP's capacity to make decisions about his education. And this one was particularly interesting, as the OS had suggested these 4 pieces of relevant information: type of provision, types of qualifications, cohort of pupils, additional rights up to the age of 25. And the expert in this case was Dr. Rippon, and I'm sure we're all familiar with her. And she had said in her oral evidence that education is broader than just qualifications. I think education also has an important component in supporting a young person's social and emotional needs. So on that basis, she agreed with a suggested formulation put forward by the local authority of an additional piece of relevant information, which was that GP would need to understand there is a social and personal development opportunity available through education. Now, again, the official solicitor thought this was too nebulous and not relevant information, and the judge agreed. He thought that by adding that to the list of relevant information, that would place greater demands upon P than others of his chronological age or commensurate maturity and unchallenged capacity. So again, basically that it would set the bar too high. So I think this is a useful judgment, not only because it looks at 3 areas of decision-making that haven't been looked at before, but also it's just a crucial reminder of what is and isn't relevant information, and not to be slotting in nebulous value judgments, as the judge described, when you are considering what relevant information should be. I'll pass over to you now, Sophie.
Thank you very much, Mary Rachel, and also Gemma. If we can move on to the next slide, please. And in fact, what I think I might do, given the time, I think I may leave this case till last, if we do have time. And the reason I say that is that this is one of the cases that we did cover in some detail in the LAG update. And it is really important. And if I have time, I would like to make a couple of points about it. But if we don't, it's in the update and you can all look at it at your leisure, should you choose to do so. So Ray, I'm going to ask if you don't mind going through a couple more slides. Stop, that's the one. And I'll talk a bit about UR, and then about the final case, and go back to Emil if we have time, and if not, we'll just move on to questions. I like this case because it deals with quite a common scenario that we come across as COP practitioners, where we're dealing with a case that may have come up as a Section 21A, person challenging detention in a care home. But what you find out is what they really want to do is move abroad, often to the country of their birthplace, where they may have very fond memories and may have maintained very strong links. And I have dealt with a couple of these cases, and generally speaking, there's sometimes a bit of a sense in which you feel you kind of have to reinvent the wheel. And what's quite helpful about this case is the guidance that it sets out, making it a bit clearer exactly what's expected. So here are the brief facts. UR was a woman of Polish origin. She's been in the UK for many years. She had a history of mental ill health, and she was in a nursing home placement, which she challenged, and there's a Section 21A application. So 3 sort of useful things about the judgment. First of all, there's a really clear acknowledgement by Mr. Justice Hayden that although the application was made under Section 21A, that is still the gateway to the full court of protection jurisdiction. So it still allowed the court to look at her capacity to make other decisions and her best interests in all other areas. So that's the first thing that I think is quite helpful. And can we move on to the next slide, please, Ray? And the second, again, sort of helpful point about this judgment is the approach that the judge takes and his warning to try and avoid what he describes as a protectionist approach. And in relation to UR, he was really focusing on, what was going to give her pleasure in the last few years of her life. And he looked at a couple of cases. One is quite an old case called GC. And Mr. Justice Hayden quotes from the judgment of Headley, as he then was, who was looking at the discharge of GC, who was a man in his 80s, to the home where he'd lived for many years. And there were very significant issues about the return home in terms of the quality of the accommodation and the kind of quite complex dynamics of the relationship which GC had with his nephew and carer. But Mr. Justice Headley sort of asked himself, where is he going to be most comfortable? And he goes on to say, for the elderly, there's often an importance in place, which isn't generally recognised by others, not just the physical place, but the structure that's associated with a place. And that's very was relevant in this case in relation to UR's wishes to return to the country of her birth. And another point that arises both in GC and also in the Sykes case is about sort of it being worth a try. So many of you will remember the judgment in Manuela Sykes by District Judge Eldergill, where he talks about how important it is to have the last few months of freedom in one's own home is worth having, even if it comes at the cost of some distress. And as in GC, District Judge Eldergill went ahead and authorised a trial placement at home for Manuela Sykes, even though there was actually a pretty good chance it wasn't going to work. And indeed, we know from subsequent press coverage that Manuela Sykes actually did return to her home fairly quickly. But no doubt, the judge was right to make that attempt at following her wishes, which again is what also happened in GC. So I quite like that reminder about the importance of weighing up P's wishes, even if the solution seems quite imperfect. The third thing, and probably perhaps most relevant, thank you, Ray, well done, it's pointed in this case, is what the approach should be in a case where the court is considering whether a move abroad is in P's best interests. And there is a really helpful, non-exhaustive checklist there towards the end of the judgment. And I'm just going to highlight a couple of things. So first of all, sort of liaison with the relevant embassy, see if they can do anything. Obviously, evidence as to physical health to travel, so that might be a fitness to fly assessment, but that you'd get from the GP, but also evidence about the impact on the person's mental health for travel. That's not necessarily going to be needed in each case, but again, one can see that it might have been important in UR's case. The other option that he's raised is getting a legal opinion regarding benefit entitlement, health and social care provision, and what is the decision-making process for someone who lacks capacity in the country that they're going to be going to? Is there something equivalent to the Mental Capacity Act in terms of protecting that person's rights in relation to decisions that they can't make? So that's quite an important factor that we need to start thinking about early on if we've got a case where a return to outside the jurisdiction is being considered. And if we could go over to the next slide, please, Ray. Thank you. And there, the next one I think is really important. So independent social work evidence regarding the viability of the proposed package of care in the relevant country. I've certainly had experience of sort of eyebrows being raised at the suggestion that we might send a social worker abroad to investigate or get evidence from abroad. And we know that independent evidence will only be permitted by the court in cases where it's necessary and it can't otherwise, the evidence can't otherwise be obtained. And this is a clear pointer that the court, is in many cases going to be satisfied that that bar has been surmounted because of the importance of assessing the viability of the proposed package of care. Because of course, really, if you move somebody out of the country and you fly them back possibly across the world, it's quite difficult for the court to review it. Once the person's left the jurisdiction, you really aren't going to be trying to bring them back home again. So that's what's important there. I think the rest, those other factors are sort of pretty self-explanatory. Transition plan, including a contingency plan, again is very important. And then thank you. And then the next few points on the list are about evidence of best interests, evidence of wishes and feelings, and thinking about the practicalities. What orders need to be made to allow the plan to be implemented? So, for example, do you need to close bank accounts? Does there need to be a financial deputy remaining dealing with P's money in this country? In order to fund care abroad, or are you closing all P's Bank's accounts and moving everything over? And then COVID-19 considerations prior to travel. And if you read the end of the judgment, there is a really useful precedent order that it could obviously be adapted to future cases. If we can move on to the next case. So I'll just spend a few moments on this case and then we'll pass on to questioning. This is a case concerning GA, who had Alzheimer's. She lived at home with TA, and there was a second son as well, HA, who had learning disabilities. And there were proceedings in the Court of Protection against both mother and the other son, HA. And TA sought permission to record hearings, because he said, and I've quoted what he said there, under no circumstances is he going to enter the jurisdiction without making a private recording of the event. And if you read the judgment, you get quite a good flavour of some of his communications. You can go on. Thank you. And essentially, Mr. Justice Cobb refused the application to record the proceedings, and he explains the reasoning, and you can see that on the slide. Although recording a court of protection case isn't a specific criminal offence by virtue of the Coronavirus Act, it is contempt of court. Mr. Justice Cobb could have given TA permission to do it, but there was absolutely no reason why he should have done. Next slide, please. But the other part of the case I think is interesting is the court's decision about how to deal with his communication. So he had been persistently complaining to the local authority, and they were treating him as a vexatious complainant, which meant that they limited the amount of correspondence that they were going to respond to. And again, here's an example of the kind of communication that was being sent. So local authority had their own way of managing his communication, and so did the solicitors for GA. But what about the court? If we can have next slide, please. The evidence was that the court was getting, several emails a day of that type that we've just seen on the last slide, and it was really becoming unmanageable. In the judgment, the judge goes back to various authorities, and I've put those on the screen, which make it clear that the courts also have the power to restrain litigants from wasting the time of court staff. And TA was injuncted from contacting the court by either phone or email, but he is allowed to write letters in the post. And also just a reminder, of course, that the Court of Protection in Part 22 of the COP rules can make orders restricting people from making further applications. So civil, essentially restraint orders preventing further applications being made without permission or imposing a filter. So that's all I'm going to say. I don't think I'll try and go back to Emil, but I wonder if we've got any questions.
Well, no, actually, Sophie, there aren't any yet. So I'm not sure if that's a good sign or a bad sign, but why don't you maybe speak briefly about Emil, because it's a really interesting case, I think, and I would certainly like to be reminded of it.
Thank you.
We've either been so thorough that people don't have questions, or we have bored people to tears.
Oh, I hope not. I really hope not. So this is a really interesting case. It's not actually in the Court of Protection, it's in the civil courts, but it's a scenario that is going to be so familiar to us. Mrs. Emil was placed in a care home in October 2008 in the context of safeguarding issue. And she was eventually placed under an authorization in August 2018. And then her condition deteriorated and she sadly died in another care home in 2019. And after she died, the local authority wanted unpaid care home fees to be paid, so they commenced proceedings. But her estate counterclaimed for damages for false imprisonment. So, you know, that's a very common scenario. And the local authority accepted at the time of the trial that she actually had lacked capacity to make decisions when she'd first moved, but only nominal damages should be paid. Because what they said is, well, it doesn't really matter because she was eventually detained under an authorization. If we'd done it at the right time, it would have been exactly the same. She didn't actually go home. So, you know, what's the problem? Nominal damages only. The judge disagreed and awarded a hefty £130,000 on the counterclaim, and the local authority appealed, and the first instance judgment was upheld. And if we can go to the next slide. So, you know, why is this important? Well, the majority of MCA related claims settle, and what we read often are approvements rather than cases where the judge is actually grappling with the quantum idea. And one of the exceptions that sort of proves the rule is Essig Bonner and King's College, which again is a civil claim where the judge made a damages award of £130 per day for a much shorter period. So Mrs. Emil was detained for, you know, a matter of years, and he didn't return to a less restrictive setting. But the evidence that came out was the family said, well, look, we would have had her home. Okay, various reasons why she couldn't go back to the matrimonial home, but she could have stayed with somebody else. Local authorities said, well, you know, you didn't tell us at the time. What the judge said was that the flawed approach to capacity prevented the local authority from carrying out its responsibility to look for less restrictive settings. So those investigations into other alternative options never took place. It was so the lack of the protection of the MCA prevented those less restrictive alternatives from being investigated. And that's what really caused difficulty for the local authority and led to these substantial damages. So I think this is a real wake-up call for all of us to remember the Mental Capacity Act. Remember that a presumption of capacity doesn't mean that you ignore the issue of capacity. And simply because somebody may appear to be compliant, don't assume that that is because they actually are able to and do in fact consent to their placement. Good intentions, said the judge, are scant consolation. That's all I wanted to say, and there's more in the legal action update. We are very close to the end, but I do wonder if anyone has anything they want to ask. Or
we've got a few questions. We've got a few questions that have come up, okay. Sophie. There's two about vaccinations, which I'm quite happy to take fairly quickly. So one of them is, in connection with vaccination disputes, if there are no existing proceedings, should it be the CCG that commence proceedings? So I would say that whoever's going to be the decision maker, the one that's going to be giving the vaccination, that public authority should be the one that's going to be bringing proceedings. And if no one's done it, then the local authority will be sort of the last option to commence proceedings. So yes, it will be probably an NHS body, but in the alternative, a local authority.
Yeah, definitely agree with that.
And then the next question about vaccinations, and then I'll turn the other one to one of you, is, oh, that one's gone. Are you aware of any judgments or comments in any judgments of how the court is likely to approach the issue of whether a COVID vaccination is in P's best interests, if restraint is likely to be required to administer it? It seems that the cases so far have been ones where a family member objects, which leads to the application to the court. I'm not familiar. I don't know if either Mary Rachel or Sophie, I know, not shaking their heads. I think there'd be some real difficulties of restraint in relation to COVID-19 vaccinations, and we've not seen any published judgments about that yet. And I think it's quite telling that in the third case I spoke about, the one before His Honour Judge Butler, it was explicitly stated that there was not an authorisation to use any force or restraint in relation to the vaccination. I think it would be interesting to see if there are cases where P appears to actually object themselves. I mean, obviously that will be all part of the best interest assessment and what restraint would be required. So I'm not aware of any yet that have been before the court and published.
No, but I can't help thinking that I mean, the way in which Hayden expresses his opinion in the judgment is that the best interest test is not particularly finely balanced. And in all of those, it's overwhelmingly felt in P's best interest for the vaccination to take place. So in the event we have a case where actually P is objecting, you know, it would be my bet that the court might well still think, yes, this is in his best interest, and we want to have a proper plan and see exactly how that's going to be worked out and think about the least restrictive way of doing that.
So there's another question here, Sophie, I'm going to direct it at you.
Oh, okay.
No, I think it's not difficult. Is it the case that the Court of Protection will not appoint a family member as litigation friend, even if one is willing to act?
No, it's not the case. There will be cases where family members are appointed as litigation friends, and the authorities that we've got say that might be the case, even if there is a slightly strained relationship between family and local authority. The key question is, can the person conduct the proceedings competently, and do they have an adverse interest? So in a lot of cases, the family member will be sufficiently involved and will have their own point that they want to put, but it's certainly not out of the question.
No, I agree. So sometimes I've had many cases where the family member is a litigation friend, but sometimes if there's a very strong conflict in views, i.e. P desperately wants to go home and the family member feels very strongly that they should remain in the care home, then it wouldn't be appropriate for them to act as a litigation friend. And so you'd ask for a different litigation friend or an ALR, and you'd invite the family member to participate separately in the proceeding. But there's certainly no bar on a family member being a litigation friend.
Definitely.
Those are all the questions we've had, and we're at 4:03. So
there was one that said great webinar, so I'll take that as well.
Thank you.
That was a timely comment just after I doubted why we'd had no questions. So that was extremely kind and welcome, and thank you to whoever said that. So there's a little for the diary, save the dates on the screen there for some upcoming things. So the mental capacity issues are on 4th of May, drug related capacity. And then we have one in June on human rights in care homes, very topical. I think.
Yep, thank you all very much for attending the webinar. And we really hope to see you in person sometime soon.
Thank you very much, everyone.
Thanks, everyone.
Bye-bye now.